Hi, ladies and gentlemen. Welcome to another episode of Candid with RMT. And today I have with me Mr. Aditya Jain, who is a practicing advocate on record at the Honorable Supreme Court of India. Welcome, Aditya. Welcome to Candid with RMT.
Hi Raghu, thank you for calling me to inviting me to your show, and it's always a pleasure interacting with you. And I've seen other of your episodes as well, which you covered, and all of them are quite insightful and I think informative for the younger generation and everyone at large.
Thank you so much. Thank you so much. That really means a lot. Started off with the concept of having just candid conversations because that is something that you miss out on. A lot of other, I would say, podcasts or episodes are largely centered around the technicalities of law.
Yeah.
That is something that just doesn't sort of give you that true candid picture of functioning. But thank you so much. Moving on to the first question, what motivated you to sit for the AOR exam?
So, ever since I was in the law school, I explored different internships and I went to law firms. I litigated, I did internships under litigation lawyers, and I did internships in companies as well. So, by fourth year, I was kind of clear that I'm going to pursue litigation as a career. And I did my internships in Supreme Court as well. So, I was quite motivated by the functioning of the court and what kind of impact it has on people's lives. So I always wanted to be a Supreme Court lawyer, and so I started working as I graduated with a senior AOR for Andhra Pradesh in Supreme Court. I worked there for a while. However, then I realized that I need to brush up my trial court and high court basics more. So I went back to my native place at Jaipur, and I practiced there for a while. Then I wrote the AOR exam finally, and luckily I cleared it. Fortunately, so I thought that quite allowed me to stabilize my Supreme Court practice to some extent, and it allowed me to have a foundation as well because I cleared it in 2020 March. It's been 3.5 years now. So in this span of time of last 3.5 years, I've become a little more recognizable as a person in Supreme Court. Perhaps prior to that I was not. So that really helped me to stabilize myself in Supreme Court.
That's quite interesting. Talking more about the AOR exam, Aditya, how has the AOR exam pattern changed over the course of years?
So the subjects more or less always have remained the same. So there are four papers. One is the leading cases, second is the practice and procedure, third is drafting, and fourth is professional ethics. And it's a subjective exam, it's a thorough subjective exam, each paper carrying 100 marks each. And you really have to, the reason I think why I succeeded in clearing the exam was because it's not an exam where you just have to mug up and write. It's an application driven exam, and you are able to write that exam well once you have a practice in Supreme Court, once you work there, once you're adept at the procedure, and once you have read the Constitution well and all those leading cases well. So it allowed me, it was a very, I would say, a transformative exercise for me, the preparation of the exam. It allowed me to read thoroughly, it allowed me to, understand the Supreme Court procedure. And it's a well structured exam, and it's a good exam to actually know your own self, whether you understand the practice and procedure, because Supreme Court practice and procedure is quite different from the other civil procedures. And Supreme Court, by virtue of powers under Article 145, it has powers to make its own procedure for its own functioning. So, in fact, the AOR exam, by virtue of using powers under Article 145(1), it's an exception to Section 30 of the Advocates Act, which says that any lawyer can practice anywhere in the country. So, exam is kind of an exception to that rule because the Supreme Court felt that probably it requires to create a system where the lawyers are probably someone is an office being an officer of the court is more accountable for the what is drafted and what is pleaded and how petitions are filed. So that is the purpose of the exam, and the preparation as well is quite interesting, unique, and quite elaborative as well. So one must have good drafting skills. One must know how to write well. One must know how to know how to summarize those leading cases well. It's not an exam where you can just mug up and write something. So that is what also motivated me to write the exam, and I thought I'd clear it because had it been a different kind of an exam, I would have never cleared it.
So, the aspiring AORs watching this episode, Aditya, what are the do's and don'ts?
That's a very interesting question. So the do's are that you must be aware thoroughly of the Supreme Court practice and procedure. For that, even if you're practicing in any other high court or any other trial court, don't get demotivated. You can still clear the exam. In fact, don't think that if you're not permanently here, you cannot clear it. But what I suggest you is you undergo a training, 1 year training, which is mandatory for an AOR exam. You go through that training. You be here, come to Delhi, go through that training process, understand the functioning. That is the practice and the procedure of the Supreme Court. Get to know how petitions are filed, get to know how the petitions are drafted, understand the nuances. Also attend the lectures which are there before the exam. There are lectures there on YouTube as well. There are books which is there. But sometimes you might get confused because there's too much of material now. So your preparation should be strategic. You should go through the past year papers, see what kind of questions come. You should talk to fellow AORs who cleared it. So your preparation has to be a 360-degree preparation. You cannot just focus on one thing. So for that you have to be here, and for that you have to do your training right. So I think that is for me is really important.
So, tell us more about the process of briefing a senior. What exactly is the role and responsibility of an AOR? He gets involved in the drafting, he gets involved in the briefing, he then makes sure that you get the relief for the client. Just talk us through all of that.
So briefing a senior is a very important process which you must learn as a Supreme Court lawyer, because this court, as an AOR or even as a non-AOR, you'll be required to brief seniors at various point of your lives. Because this being the final court, obviously it has kind of a face. Seniors kind of have a face value. So while briefing a senior, what I learned from my senior was that you should have excellent command over the facts of the case. So the mistake which most people do while briefing a senior is they don't understand the facts. They don't make an effort to know the facts from the briefing counsel or the client. So you have to really make an effort, and that's why the trial court and the high court practice helps you, because you know the facts at the back of your hand and you know the relevance of those facts. So you understand the facts, you prepare a narrative, you chronologically arrange those facts, you understand the relevance of each fact, and then I would say when you go to brief a senior, you prepare a good list of dates, you tell the senior the relevance of each fact, and then narrate probably a good story to a senior for him to make sense of it. The law part is important, of course. You are telling the law, this how the law developed over the years on this particular point. But that again, the senior has more expertise than you over the law, I would say. You have what your job is as a briefing counsel is to give him clarity with regard to the facts.
Right. I couldn't agree more. This sort of recent judgment of the Supreme Court, which talks about name lending as a practice, which is something which is frowned upon. What are your views? Clearing the AOR exam, has it just sort of come down to your passing of your signatures on the petitions, or is it something which is you know been a practice over the years and now is just coming to the light? Tell us more about it.
So, as far as I know, this has been a practice for quite a while now, and the issue was first taken up in the Supreme Court in 2010 in one Vijay's judgment, in which finally that petition got dismissed, but the concerned AOR was given a warning in that case. Thereafter, one more case of Indri Rameshwar Prasad, that was again one case in 2013, in which again one particular AOR was given a warning and he was kept under check for 1 year. by a bench comprising of Justice B.S. Chauhan. Thereafter, this recent case where Justice Kaul and Dhulia had observed that the concerned AUR or the concerned lawyer, they have moved a petition, interesting petition, with a prayer to declare Article 20 and 22 as ultra vires. So the prayer was such that the bench got really annoyed and they called the AUR as to why such prayer, why did you settle such a brief, or why did you sign such a brief. So the role of an AUR, you have to understand it from where it came from, and it comes in part 4 of the Supreme Court rules. And there are duties of an AUR which are mentioned specifically in part 4, and part 4 emanates from Article 145 and read with section 30. So you have to really understand what are the duties of an AUR. He's not merely a signing authority. I mean, any brief which comes to an AUR and he has to sign it, he has to make sure it's his duty that that brief is in order. That brief is as per the Supreme Court rules. It actually allows the court to have a better understanding. So an AOR is kind of an intermediary between the court and the lawyer or the briefing counsel. So he has to mandatorily fulfill those duties. The reason why such things are happening, I don't know why they are happening, but the court should deal with this with an iron hand. And even the AORs, the senior AORs and the junior AORs, I think they need to be trained better in terms of the functioning. Because I remember when I cleared the exam, there was training prior, there were classes prior to the exam. But what happens once you become an AOR? Is there a training process for that? Is there a short training process which you have to go through? Or you just become and you have to just read the rules? So I think there has to be a proper training post the exam as well for the successful people who clear the exam. And this training could be then conducted by, I think, senior advocates or senior AORs and also some judges if they have time. So once this happens, I think the process would be better. People would be more aware of the duties. People would also be aware of the things that they are not supposed to do, which is very important. And the gradual fall in the credibility of AORs over the last 10 years or 5 years will then not lead to severe consequences. It would again redeem the reputation of AORs. So I think that could be one suggestion which could help the system.
Talk us more about SCORA. What exactly is SCORA? What is the role of SCORA?
So the SCORA is an association of advocates on record, which primarily the duties of a SCORA is to deal with the welfare of AORs and to determine the rules, the procedure, and how AORs conduct themselves. So SCORA has also, as you rightly said, SCORA can play an active role, and it can conduct training workshop, or it can also regulate to some extent the conduct of AORs. Because SCORA has, if you see the history, SCORA has filed various petitions which has led to some monumental changes in the constitution.
Absolutely.
Be it the second judge's case,
Absolutely.
and also the third judge's case, and other petitions which has affected, which has led to better functioning of the bench and the bar. So SCORA has played a monumental role in terms of the judicial processes and the functioning, and they have raised certain issues of credence, in the few past as well. So I think SCORA could probably create a mechanism for proper training of AORs. I feel.
Right. I mean, the role of an association has to be fundamentally in alliance with the factors that affect the stakeholders of that particular association.
Yeah.
If it's not for the welfare of that particular of those stakeholders in that association, then the whole point of forming that association, like the purpose gets defeated. So one of the most active bodies, I would say, bringing about fundamental change is in fact SCORA. What strategies do you employ to ensure the success of your client's case in the Supreme Court?
Supreme Court being the last court, it's also a constitutional court and it's the last court. So the practice here is very, I would say, it's not an easy task, and you really have to be very good at your drafting. So what I learned initially was when I started practicing that Supreme Court practice is quite different from a regular High Court and a trial court practice. And what you draft is something which is really important because at the admission stage, you get just 1 minute, 30 seconds, 2 minutes you get to convince the court of law, and it's that time where you have to really, convince
Make or
the
break.
court. Yes, make or break. You're right. And also, the drafting becomes really important, especially the synopsis, the list of dates, because judges read that and come
Correct.
on an admission day. So you have to really, again. So if you understand, if you can point out very clearly where the trial court or the high court has gone wrong, if you have very good command over the facts, and you can create a very good list of dates, which is easy to understand. Now, a lot of firms and yours, I feel they draft a very long synopsis or a list of dates, which that might be right, but which I do not agree with because I think it should be more simpler and clearer for the judge to understand. Because first you have to convince the judge, and then he will only pass order in your favor. So you have to convince him through a draft. It's only then when you get a chance to convince him through your arguments. So the draft should be very clear. They should be very easy to understand. They should have very good clarity of the factual position as well as the legal position. So you cannot just tell the court that this is the legal position, so this will be the interpretation. Leave the interpretation part to the judge. You have to just make him aware of the legal position, and that has to be done again chronologically. And same about facts. You have to tell a coherent story. You have to build a narrative around it structurally, and you have to do it in a simpler manner. So the better your draft is, the more chances you have of getting success in the last court, which I also realized from my personal journey, because as I started drafting more petitions, my drafting improved further. I learned it through getting senior awards. I read varied drafts. So you should read as many drafts as possible wherever you get an opportunity. Just try to read as many briefs and just try to see which brief you feel is good, which brief you feel is not good, and how judges deal with those briefs. So all these things are very important.
Yeah, I mean, so far I haven't gotten the opportunity of, briefing one of my own cases to a senior or doing that, entire process. But yes, back in my law school when I was interning, I did get a lot of chances to assist my seniors and be a part of that process. And you're absolutely right. I mean, you keep it crisp, you keep it simple, you keep it concise. And when you brief a senior, if the senior sees that, I'm sure the judge is going to see that as well.
Yes.
So if the senior is in line with your draft and he sees that, he or she sees that, this is something that can be worked with, I'm pretty much sure that, he or she can then put that up before a judge.
Yes.
Moving on, example of a particularly challenging high profile case you have handled in the Supreme Court, and what was the outcome?
So recently, I, along with my boss, were involved in this Article 370 petition where we challenged that in the Supreme Court, and we got an opportunity to brief Mr. Sibyl, and I got a chance to read that matter thoroughly, understand the constitutional perspectives to that, and the grounds of challenge. So that was a very nice experience which I had. Apart from that, I was also, the subject matters which are sub judice, which I cannot give my comment upon. So which are pending. One is the issue relating to UAPA, whether gold smuggling falls under the definition of financial terrorism, and also one other issue. Recently, I represented the victims of Jaipur bomb blast, in which we beat Mr. Venkatramani and also Mr. Rawatgi. So that was also one case which we are doing. Which these kind of cases have constitutional ramifications, and they involve question of law. So they always have a special place. In fact, early on in my career, when I was with my senior, I was representing various state PSUs and the state government. So that really allowed me to understand the side of the state as to what they think, what their policy is. So I got a chance to do that. Also, I would say recently there was this matter which flew from my state high court, that is Rajasthan, to Supreme Court, and which I got a bail cancelled. That order was me, and that was very satisfying. It was a double murder case, and I was representing the victims in that. So these are some cases where I felt I learned a lot, and it was a good journey for me to be a part of these cases. And apart from that, each one of us are doing different cases in our own capacity, and every case which we hear, which we read about, is definitely a very good learning opportunity.
Definitely, definitely. As a young practitioner who someday sees himself practicing before the Honorable Supreme Court, it is so encouraging to see, AOR such as yourself, who chose the path of doing that struggle, hustle, sitting for the exam, not being from Delhi where the Supreme Court is situated, coming to Delhi, making those changes, adjustments, and then, you know, getting that satisfaction. So that is very encouraging, and it gives a lot of motivation to young lawyers such as myself to just go for the AOR exam. I mean, I'm like 5 years into the experience, so I'm eligible next year. So I might just sit for it and come to you for some tuition and coaching and the tips for the AOR exam. Coming to the ending part of our podcast, what are the funny anecdotes from court? And this is something that I often ask my guests. Someone has something or the other to say about the anecdote.
So, a lot of funny incidents keep on happening, and with you also personally, or with someone else who you witness in the court. So, like for me, I was a junior in the profession and I was practicing before the Supreme Court and in my state high court. And I did not know the concept of admission initially, first year of practice. So I appeared before a judge in my high court, state high court, and I told him that matter was initially listed for notice. So I directly went and told the judge, you admitted. So the judge got furious at me and told me, where have you learned this from? You tell us the facts, you tell us the law. And I thought the judge probably admission is a matter of course, and it's then after that you address the judge. So that was, I was just 1 or 2 months in the profession and I did not know the concept of that. Also, there was a lawyer who in the trial court who used to sometimes come drunk to court sometimes. So everyone knew about it, and no one actually. A lot of people made him understand that don't do that, but he was relentless in his pursuits of excellence. So he did not stop. But again, one fine day he argued in his capacity as a lawyer. In his own zone he was, and the judge got to know. So he was reprimanded. So again, to witness him in the court in action, to address the judge in his own style, inimitable style, and he was good at law, was again an interesting, funny thing which happened. So more than I think in the Supreme Court, a lot of funny things happen in the trial court.
Yeah, that's true. सुप्रीम कोर्ट में देना हो ना कि हाँ चलो टॉप कोर्ट है यहाँ थोड़ा संभल के मतलब इतना वो नहीं कर सकते बट या ट्रायल कोर्ट दे लाइक खुला मैदान है it's our battlefield, you can do whatever you want to.
Yes, especially when some lawyer is examining a witness.
Yeah.
So a lot of funny things happen.
Yeah, that is something which I should report next on our podcast. Yeah. The cross-examination, the entire narrative of one particular cross-examination which a lawyer remembers, and how he or she sort of, got that person to that is something that I should do next. Absolutely.
Yes.
But thank you so much, Aditya. It was my genuine pleasure for having you on board. Thank you so much.